If you want awesome products at great prices, check out the description. A controversial legal strategy is sweeping across British universities, raising serious concerns about freedom of speech and the right to protest. Shakespeare Martineau LLP, a prominent law firm, has been actively advising universities on obtaining sweeping injunctions that effectively ban unauthorized protests, potentially leading to lengthy prison sentences and substantial fines for students. This revelation, uncovered by The Guardian and Liberty Investigates through Freedom of Information Act requests, shines a light on a concerning trend. The firm, having successfully secured a year-long ban on unauthorized protests at Cardiff University, a ban so broad it could encompass activities ranging from industrial action to seemingly innocuous events like bake sales, actively promoted this controversial legal tactic at a webinar last October. Documents obtained reveal that several universities, including Reading, Exeter, Northumbria, Hertfordshire, Birkbeck, Bath Spa, Liverpool John Moores, Falmouth and Warwick, registered for this webinar, raising questions about the extent of its influence. While some universities claim staff attendance was routine and doesn't signify endorsement, the webinar slides explicitly positioned these newcomer injunctions, designed to target unknown individuals and those not directly involved in initial protests, as the future of campus protest management. Cardiff University's injunction, stemming from conflict over a pro-Palestine encampment, allows for prosecution for protests on significant portions of the campus without prior permission, requiring applications 3 weeks in advance. This has drawn condemnation from legal experts, who argue the injunction's wording is excessively broad, potentially stifling even lawful demonstrations. The UN Special Rapporteur for Freedom of Assembly, Gina Romero, described the law firm's actions as despicable, highlighting the ethical implications of profiting from the restriction of human rights. The European Legal Support Centre echoes these concerns, characterizing the legal tactic as a chilling precedent given the legal complexities and financial burden it places on students fighting such injunctions. Shakespeare Martineau maintains the injunctions only target unlawful encampments and do not prohibit lawful protests with prior permission. However, independent legal analysis contradicts this assertion, suggesting the wording permits a much wider application. The firm's spokesperson emphasizes their work with universities aims to balance peaceful protest with the prevention of unlawful activities and the upholding of campus safety and legal compliance. Cardiff University, while maintaining its commitment to free speech and peaceful protest, cites escalating practices that posed risks to protesters and the wider community as justification for its actions. The injunction's effectiveness, however, remains contentious. The Office for Students, in guidance issued last week, advises universities against enacting sweeping protest restrictions, a move welcomed by free speech advocates but acknowledged as insufficient to prevent universities from seeking such injunctions independently. This is further underscored by the recent granting of similar temporary injunctions to 2 Cambridge colleges. The Cardiff injunction faces review in July 2026, leaving the future of campus protest rights in a precarious state, hanging in the balance of legal interpretation and the ongoing battle between the right to protest and the desire for campus order and security. The narrative underscores the complexities involved, prompting questions about the balance between maintaining campus order and upholding fundamental rights to free speech and assembly. The legal battle continues, with the implications reaching far beyond the immediate cases, potentially reshaping the landscape of student activism and university governance for years to come. The story raises crucial questions regarding the role of law firms in shaping university policy, the interpretation of freedom of speech within the context of higher education, and the long-term impact of such restrictive measures on student engagement and democratic discourse within university campuses across the UK. This ongoing situation demands careful consideration and a robust public discourse, ensuring that the principles of academic freedom and the right to peaceful protest are preserved, balanced against the legitimate concerns of university authorities regarding safety and order. The tension remains, setting the stage for a continuing legal and ethical debate that will define the future of protest on UK university campuses. The implications are vast, touching upon fundamental human rights, the limits of legal authority within educational institutions, and the very nature of free speech in an increasingly complex and contested social and political landscape.